The concept of consequential damages is among the most important yet least understood concept within design and construction law. I like to joke that if you asked a half dozen people what consequential damages are, you'd get a dozen answers. And that's because the phrase consequential damages is not a term of art. It doesn't have any fixed meaning of universal application from project to project and contract to contract. Typically speaking, though, consequential damages are going to be the damages that flow indirectly from some breach, like a breach of contract or some sort of negligence. Now that's a sort of unsatisfying definition, so let me give you a ridiculous hypothetical that might make it a little bit clearer for you. Imagine a hypothetical project where an architect is designing a casino for an owner. And let's assume that the architect's design has an omission. Let's say that on the hardware schedule, the architect forgot to include a doorknob for the front door. And this resulted in two different kinds of losses that the owner took. One, let's assume for a moment that in between the time when the omission was made and when it was noted, the cost of doorknobs doubled. Okay, that's one bucket of damages. And then, what makes the hypothetical ridiculous is the second kind of damages. Let's say that the lack of a front door knob prevented the project from opening for a day, right? Because the gamblers couldn't open the front door to come in and lose their money to the casino. So there's all the lost revenue that the casino lost out on for being closed that extra day. The delta between what the doorknob should have cost and what it actually cost, the increased commodity price, that's comparatively small. That's the direct damages, okay? The consequential damages in this ridiculous hypothetical would be all of the money that the casino didn't manage to win from the gamblers in that one day where the project opening was delayed. And so you can see the relative size of these two buckets of damages. The direct damages, the increased price of the doorknob, are almost so small that it's not worth talking about, but the losses that the casino took by virtue of not being open for that one day could run into the millions and millions of dollars. And so in a contract negotiation, whether it is an owner design professional agreement that's being negotiated or an owner contractor agreement that's being negotiated, you often get to the question of whether or not there will be a waiver of consequential damages in the contract. In other words, will one party be limited to seeking only direct damages from the other party, or will they have the ability to sue them not just for direct damages but for consequential damages? And because consequential damages are remote and they're indirect and they can be very big, this is something that gets people animated. Contractors and design professionals understandably are concerned about the possibility of being exposed to consequential damages. One comparatively small mistake could lead to very substantial consequential damages, which could hypothetically put them out of business. So design professionals and contractors are usually pretty eager and often insistent on the idea that there be a waiver of consequential damages in their contract. On the other hand, if you have an owner that is building, something that is complicated and expensive, a sports arena or a hospital or, whatever the case may be, a casino, they could really suffer very substantial losses, and they could have their business operation shut down, as well if they suffered millions of dollars of consequential damages. And some as they can be pretty insistent upon, the idea that the design professional or the contractor be exposed to not just the direct damages, but also to the consequential damages. And, in this staring contest, this frequent debate between the two parties, one that wants to expose the other side to consequential damages and one that wants the consequential damages to be mutually waived by all parties, there are nuanced positions between the bookends. The bookends being you're either on the hook for consequential damages or, the idea of consequential damages is totally out the window. There are nuanced positions in the middle. And if you find yourself in a staring contest in the negotiation of a design or construction contract about the question of whether consequential damages will be waived or not, a design or construction attorney would be able to help you find the nuanced position, find the compromise between the extreme bookends of either insisting that consequential damages be waived or insisting that the contracting parties be exposed to consequential damages.